911, what's your emergency? 911, what's your emergency?
Be advised, Car 4 has control of the pursuit. Proceed with caution.
Hello, everyone. Good evening, and welcome to Behind the Crime Door. How is everyone tonight? It's so good to see all of you. I never get tired of listening to Tech Death's music. I could sit here and listen to that intro over and over and over again. I just love it. I just can't say enough, guys. He's amazing. So talented. But anyway, how is everyone? I hope you're all doing well. Hi, Gail Hurd. How are you? Good to see you. Hey, Stephanie. Hey, Tech Death. How are you, my dear? Hi, John. Good to see you. Hey, Mitzi. How you doing? Hey, Dandy Lioness. Hey, Butterfly Kisses. Aw, sorry, Butterfly. You are welcome to chill here with us. Hey, Lynn, GMB, how are you? Hi, Sees Through. Hey, Julianne, friend, how are you? Hi, Frank Meister, how are you? Hi, Carol Durant, how are you? Good to see you guys. Hi, Willow Rain 73. Good to have you here. So yeah, there was some filings that took place in the Delphi case. Again, we're going to continue to have this, you guys, until the trial date, which is scheduled in 3 months, if you can believe that. We are supposed to be at trial in this case within 3 months. So the very beginning of January. So thank you, Carol. Let's see. Oh. So we're going to talk about the filings. We're going to talk about what's going on. We're going to talk about how the defense is pushing that Tony Liggett and the Delphi investigative team lied, basically, to get their search warrant. And they just keep pushing this. So we're going to discuss this tonight. Hey, Sharon Parker, how are you? See you. And I want to thank Frank Meister and Deb from True Crime Notebook for constantly keeping me updated with all the newest court filings. I haven't had to go find them myself because they are so amazing at sharing them with me. And I so appreciate both of them immensely for that. Hey, CJK, you snuck in here. I didn't see that. Hi, Danger Dave. How are you? Hey, Purdue, how are you? I can't wait to see you in just a couple weeks. Oh, it's going to be awesome. I can't wait. I hope I get to see Frank Meister and some others of you that will be at the walk on the 21st. Hey, Brian Tampa, how are you? Hey, Daisy. So I wanted to just remind everyone that is not aware, but Randy Gravitt is hosting the Memorial Walk on the 21st of October. It's a Saturday at 12:30 p.m. in Delphi at the trails. He does this a couple of times a year, and they have a walk. They just go out and people meet and remember and memorialize the girls. It's all about the girls. And oh, thanks, Dave. I love my Hoyas. I have this whole room. I have a huge picture window over here on the other side of me. That's a south facing window. And I have plants hung from my ceiling all in front of that window. So, yeah. I haven't heard, Sharon. I don't know the answer to that. Frank Meister might know. Oh, you're very welcome. So, but yeah, that's happening on the 21st. And I will be in Delphi for that. So I'm looking forward to it. And let's see. I bit myself earlier today on my cheek, and it's bothering me now that I'm talking. So bear with me, guys. It's always something. The first thing that I wanted to talk about before we jump into Delphi is I'm sure that you guys are all aware or have heard of the missing 9-year-old out of Moreau Lake in New York over the weekend. And I wanted to talk about that just a little bit because it really things just happened so fast in that case. And I'm just so impressed with law enforcement, and I want to call them out on that. Hey, Deb. Good to see you, my dear. Thanks, Frank, for updating us. I give and send Randy all of my prayers and hope for a speedy recovery for him. And I look forward to getting to meet him on the 21st. Randy has done so much for the girls over the years, and he's just a gem in this community. He really cares about this case. He cares about justice for the girls. And yeah, it's just, I just feel bad that he's been not well. So we are keeping him in our prayers. So let me see what's going on here and why I can't. No, I don't. No. Hold on a minute, guys. I'm having issues with my computer and I'm not sure why. So just give me a break here or a moment here for a second and I will. There we go. Okay. So on Saturday, Charlotte Senna went missing on Saturday. Her and her family were camping in Moreau Lake State Park in New York up by Albany. And they weren't that far from their home, but they just went there to spend a quiet weekend with friends and just camp. It's a really nice campsite location. From all the photos and things I've been able to see, it looks like a really kind of really nice place. They say that this park is one of the largest state parks in the state of New York, and it is extremely dense. And so she had been out riding her bike with some friends / cousins, and around 6:15 or so, she asked her parents if she could go around this circle drive that they were riding on one last time by herself. And they told her that that was okay, and she did. Well, she disappeared. She, within 15 minutes, she wasn't back. And her mother, being, how moms have that sixth sense we have, knew something was wrong. And they tried calling for her and looking for her, couldn't find her. And so they ended up calling police and reporting her missing. 45 minutes after that, they found her bike. And it had been, her bike was standing up and it was on its kickstand. But there was no sign of Charlotte anywhere. And they were just beside themselves, as you can imagine any parent would be in that situation. And, it just didn't seem, by what they were seeing, it didn't seem like she had wandered off. It didn't seem, she wasn't the type of girl to do something like that from all accounts. And they just weren't sure. But once law enforcement showed up, they started thinking that it was looking more and more like an abduction, like somebody had taken her. The governor of New York got involved in this case. She was very vocal over the weekend and talking to the press and giving press releases to keep people updated on the search and what was happening in the case. They had law enforcement from every direction descended upon this state park, you guys, and it happened in a quick amount of time. They had the New York State Police, the New York State Park Police, they had the FBI, because the FBI always gets involved in a child gone missing in this kind of a scenario, and especially a child under the age of 12. And Charlotte was 9. And so they continued the search. 24 hours went by, 36 hours went by, 48 hours went by. The searchers were vigilant. They were combing this entire park, state park, which they had closed to the public. And, you know, they were pulling up a dragnet of cell phone pings in the area to try to get an idea of all the cell phones that were in that park area at the time she went missing. And they were quick to get that information. It happened for them pretty fast. Well, yesterday morning, around 4:30 in the morning, the state police, New York State Police, was at Charlotte's home, and they were just there to protect the home and keep the home under surveillance while the rest of the investigation was going on, because the family was remaining at the state park and the campground, because that's where they thought she might return to if she was gone. So they stayed there. Well, at 4:30 in the morning, yesterday morning, law enforcement observed a car pull up in front of her house at her mailbox and drop something or leave something in the mailbox. So law enforcement, the investigators, went to the mailbox to retrieve what it was. They took notice of the car. They took notice of the license plates, the best they could. And once upon retrieving what they got out of the mailbox, they found out that it was a ransom note stating that the person that wrote the note had Charlotte. Well, this got them in like hyper mode, and they immediately sent this letter to the crime lab, and they did forensic testing on it to see if they could get any kind of DNA or fingerprints or whatever. They were able to obtain a latent fingerprint off of the letter. They ran that through the AFIS for the state of New York, and they got a hit yesterday afternoon about 2:00. And it was for a person who had been in the system, but was in the system for a DWI from back in 1999. And the person was identified as Craig Nelson Ross Jr., who is 47 years old. And he had no other priors or other arrest record. So they didn't know who this guy was or anything. So they quickly moved, found out where he lived, and that he was supposedly living with his mother about 20 minutes away from the state park. So they quickly amassed a team, and they closed in on this double wide trailer that the mother lived in, as well as the he was staying on the property in some sort of a RV or camper. And they were able to basically quickly get into that camper. And he fought them. He put up a fight, and they were able to subdue him and place him under arrest. And they found Charlotte there in the camper with him inside of a closet. And they said that she was in good condition. She was in good physical condition, which was unbelievable. The whole thing to me is absolutely unbelievable. First of all, we don't have very many, few and far between do we have stranger abductions of children demanding ransom. It's very, very rare. So this was completely out of the norm, and it sent, like I said, it sent everybody kind of for a loop. So I want to say that I am absolutely thrilled, beyond thrilled, that they were able to recover her. Because after the weekend passed, I was really having a sinking feeling like this is going to be another one of these cases where we don't find her, or she stays missing, or we find her deceased. And it was absolutely a miracle that she was found. And we just don't get that kind of a story ending in these stories. From what I can tell, there are a lot of rumors out there, and we haven't had a press conference by the police yet. So I'm waiting for that to talk. He was arraigned today and charged with kidnapping. I don't know if there's going to be a lot more charges against him or not, but I think that the response that came from this case, so quickly the parents acted. They didn't wait. They didn't kind of wait around to see what happened. She'll turn up or whatever. The mom was beside herself, and she knew something was wrong. She knew this was not like her daughter. So what's on this guy's mind? And, it sounds like this was all done for money. And all I can say is, thank God that's what it was about, and that she was not subjected, it doesn't appear to be, to any kind of physical abuse. Now, the emotional trauma and just the trauma from being kidnapped, that in itself is going to be enough for her to have to deal with. But I am certainly hoping that what we're hearing is true, and that she was not physically harmed by this person. It's just bizarre that you have a person that has no background at all, except for a DWI back in 1999, who now all of a sudden, at the age of 47, decides to do something like this. And we don't know any of that, Stephanie. They haven't told us any of that. We are waiting, like I said, for a press conference from authorities to give us the particulars. So I think that it's, I thought what was ironic about it, and it just goes to the old adage that, criminals are not the smartest bulbs in the box. He didn't use gloves, and he left his fingerprints. I think that anybody that watches true crime or follows true crime knows that that's a no-no. You don't, if you're trying not to get caught, that's something that you wouldn't want to do. But thank God he did. And that it was able to be resolved. So yeah, I wanted to just, touch on that and, say how happy I am that we got a resolution that we don't often see in these kinds of cases. And I wish her the best. I hope that she is able to come back and bounce back from this, and that she, can heal and get back to being a 9-year-old fourth grader living her best life. I'm sure it's going to be a struggle for a while. So anyway, as you guys probably have already heard, because I know how the community is in Delphi, there was a couple of motions, and we're going to talk about those. So there was a supplemental motion for the Faxx hearing that was filed by the defense for Richard Allen. And they filed this on Monday. And this was a follow-up, basically, or a supplemental to our 134-page motion, guys. And basically what this motion is, which I think is hilarious, because remember we talked on my last live about the prosecution came out and said that 134-page document was unprofessional. This is the defense's attempt at making their 134-page document professional, in my opinion. The purpose of this supplemental was to bullet point everything and try to make it professional. And so it basically states that in support of said supplemental motion, defendant Allen states as follows: on the 18th day of September 2023, the defendant Allen filed his motion for Faxx hearing. In paragraph 8 of said motion, defendant Allen made general references to the preliminary showing required prior to the admission of Faxx evidence at a suppression hearing. However, defendant Allen now realizes that he did not articulate in detail the actual burden of proof associated with said preliminary showing. Number 2, to mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits or otherwise reliable statements of witnesses should be furnished, or their absence satisfactorily explained. And that's Faxx versus Delaware in 1978. Number 3, the question becomes what exactly is the burden of proof associated with the preliminary showing. In People versus Lucente, in 1987, the Illinois Supreme Court addressed the issue of the burden of proof related to the preliminary let's see, hold on. The preliminary showing. In pertinent part, the court stated as follows that Faxx expressly states that in order to prevail at the hearing, the defendant must prove his claim of perjury by a preponderance of the evidence. If the preponderance standard is to apply at the hearing, it follows logically that the threshold requirement must be something less. Thus, the precise standard lies somewhere between mere denial on the one hand and proof by preponderance on the other. Put another way, the preliminary burden must be sufficiently rigorous to preclude automatic hearings in every case, but not so one row to be unachievable. Therefore, Allen's burden could be akin to the well-recognized burden of reasonable suspicion, the lowest of the standards employed in the criminal justice system. Gail, thank you so much for your super sticker. Thank you. Thank you. I appreciate it very much. Thank you again. You guys are great. Therefore, Allen's burden could be akin to the well-recognized burden of reasonable suspicion, the lowest of the standards employed in the criminal justice system. The purpose of the substantial preliminary showing requirement is to discourage abuse of the hearings process and to enable spurious claims to wash out at an early stage. Franks versus Delaware, 1978. At its very foundation, the preliminary showing requirement is intended to discourage litigants from utilizing the suppression process as a means of seeking an additional opportunity to cross-examine the state's witnesses. Hence, the rule requires that the defendant assert more than basic allegations. Instead, the defendant must offer up affidavits and other supporting documents to prove up defendant's claims that state actors engaged in conduct that demonstrated intentional or reckless disregard for the truth. In number 5, in People versus Lucente, the defendant was charged with possession of a controlled substance with the intent to deliver. The defendant's arrest was driven by a Chicago police officer's execution and submission of a complaint for a search warrant. The complaint was based on evidence provided by a reliable and unnamed informant that the officer claimed to have worked with on numerous occasions prior to filing the complaint. The informant claimed to have visited defendant's apartment and purchased marijuana while inside. The complaint also in detail articulated the reasons why the officer found the unnamed informant to be reliable. Based upon the officer's sworn statements, a warrant was issued and drugs were recovered in the defendant's residence. This recovery led to the defendant's arrest and filing of formal charges. The defendant responded by claiming that he had an alibi. Attached to his Franks filing, the defendant included several affidavits signed by the defendant's family members indicating that he, the defendant, was at another location at the time the unnamed informant claimed to have rendezvoused with him at his home. Despite the fact that all the affidavits offered by the defendant were statements from family members and therefore somewhat self-serving, the court still found that the defendant met the threshold requirements to offer up the Franks evidence at the suppression hearing. This is to say that the very nature of an affidavit and its inherent indicia of accountability and accuracy was enough to overcome the relatively low standard of proof required to make the preliminary showing required by Franks. Number 7, in this case, defendant Allen has done far more than offer up self-serving affidavits. In fact, the bulk of supporting documentation in defendant Allen's offering includes, but is not limited to, affidavits from law enforcement officers working the case, sworn deposition statements from law enforcement officers, numerous police reports, and audio and video of witness statements taken by law enforcement officers during the investigation. The veracity of the supporting material offered up by the defendant is far more reliable on its foundation than self-serving affidavits offered up by the defendant in People versus Lucente. Therefore, it stands to reason that defendant Allen would likewise meet the requirements burden of proof for the preliminary showing such that his Franks evidence should be admissible at the suppression hearing. Number 8. The relatively low legal threshold was also demonstrated in the case of People versus Zamantis, and this was the Appellate Court of Illinois, 1st Division, 5th Division, 1989. In this case, a police officer sought out a search warrant for defendant's home. The officer alleged under oath that he had received information from a reliable informant that said informant placed sports wagers, illegal sports gambling, with defendant through a specific phone number registered in the defendant's name. The officer further swore that he confirmed with the phone company, Illinois Bell, that the phone was in fact registered in the defendant's name. In response, the defendant filed a request for Franx's hearing, alleging through his own affidavit that the phone number was not registered in his name and attached an Illinois Bell telephone bill showing that the number was not registered to the defendant. The court found that the affidavit and single supporting document was enough to meet the preliminary showing, and therefore the defendant was entitled to a hearing. Number 9, again, the defendant offers up a self-serving affidavit supported by a corroborating business record and met his burden as it relates to a preliminary showing. Defendant Allen's memo and attachments amount to far more. Allen offered up dozens of pages of police reports from various law enforcement officers, all of which focus on individuals other than himself that could have committed these crimes. Deposition transcripts from law enforcement officers that contain testimony acknowledging that others may have committed these crimes, and finally, both written and recorded statements of witnesses on or near the trail on the day in question, who articulated facts entirely inconsistent with those offered by Sheriff Liggett in his affidavit supporting the search warrant. Number 10, assuming that the necessary threshold showing has been made so that a hearing must be held, the next question revolves around who has the burden of proof and what exactly is the legal standard at the suppression hearing. Franxx holds that the allegation of perjury or reckless disregard must be established by the defendant by a preponderance of the evidence. Franxx versus Delaware, 1978. This standard and the circumstances surrounding evidentiary showing are referenced in paragraphs 6 through 10 of defendant Allen's motion for Franxx hearing previously filed with this court. Respectfully submitted by Bradley A. Rosie, attorney for the defendant, and Andrew J. Baldwin, attorney for defendant. So that's one motion. The other motion was for discovery deadline. Comes now the defendant Richard Allen by counsel Bradley A. Rosie and Andrew J. Baldwin, and respectfully requests that this court set a discovery deadline in this cause. In support of said motion, defendant Allen states as follows. On October 28, 2022, the state filed an information alleging defendant Richard Allen committed 2 acts of felony murder. Number 2, the jury trial in this case is set to commence on January the 8th of 2024. Number 3, throughout this proceeding, the defense has received discovery in the form of external hard drives, thumb drives, disks, and written documentation. The defense has picked up said discovery, usually within a day, but no more than 2 weeks of the discovery being made available. Number 4, said discovery was provided by the prosecutor to the defense on the following dates, all of which are memorialized in acknowledgement receipts executed by the defense and or defense representatives on the following dates. Discovery that was received before the first round of depositions. Envelope dated December 7th, 2022, an envelope dated December 21st, 2022, receipt dated December 21st, 2022, receipt dated February 13th, 2023, and a receipt dated April 20th, 2023. A receipt dated May 23rd, 2023, a second receipt dated May 23rd, 2023, and a receipt dated June 27th, 2023, totaling 16 hard drives, 4 flash drives, and 1 disk. Discovery received after the first round of depositions. The receipt dated September 8th, 2023, a receipt dated September 18th, 2023, and a receipt dated September 21st, 2023, and a receipt dated September 27th, 2023, totaling 14 hard drives, 5 flash drives, and 3 disks. The state of Indiana has indicated to defense that the more recent discovery it has provided, September 8th through September 27th, may contain some discovery that the defense has already received. If that is accurate from reviewing the state's itemization of newly discovered evidence, the defense believes that very little of the new discovery has been previously discovered. However, number 6, the defense has had very little time to compare the new discovery dumps of 14 hard drives, 5 flash drives, and 3 disks received on or after September 8th, 2023, with the older discovery received before September 8th, 2023. The defense conducted the first round of depositions in this matter in early August 2023. The defense anticipates conducting at least 30 to 40 additional depositions between now and the trial date, but has been reluctant to set additional depositions until it is confident that it has received all of the discovery, and also until it has had a chance to review the vast amounts of newly discovered evidence received on and after September 8th, 2023. The September 8th, September 18th, September 21st, and September 27th receipts referenced above contained in part discovery that was generated by the state of Indiana after the defense conducted its initial round of depositions. It was during this initial round of depositions that the state of Indiana and the Unified Command learned that the defense was aware of law enforcement's lack of investigation and focus on certain suspects related to Odinism, as detailed in the defense's recent Faxx filing. Number 10, some of the recent discovery that the state of Indiana has provided is directly related to the Odinism aspects of the case, but was only turned over to the defense after the state of Indiana was aware that the defense was cognizant of the Odinism aspects of the case. Number 11, the missing Odinite evidence that was finally turned over by the state of Indiana following the first round of depositions includes, but is not limited to, multiple interviews of Elvis Fields, which the defense has reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. Multiple interviews of, I'm not going to say the rest of their names, which the defense has reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. An interview of blank, which the defense has reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. A letter from former Rushville investigator Todd Click, which is exculpatory in nature in that it provides the name of an investigator who believes that the evidence strongly supports that certain suspects in Delphi, Logansport, and Rushville committed the murders. This is a letter that the state of Indiana has had in its possession since May 1st, 2023, but only turned over to the defense once the state of Indiana knew that it was only a matter of time before the defense would learn of its existence. E, a report roughly 85 pages in length that has been reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. Letter F, several search warrants signed by judges in Marion County pertaining to certain internet and phone records, including at least one unknown person who admitted to killing the girls, even providing details unknown to the general public of the crime scene, such as the fact that he used a knife in a way consistent with the manner of death, and also claiming that he used a gun but never fired it. 12, having only had a chance to barely touch the surface of the vast amounts of newly discovered evidence the defense has received in the last 24 days, it is hard to know what other exculpatory evidence may be found in 14 hard drives, 5 thumb drives, and 3 disks, as well as the paperwork that was also provided since September 8th of 2023. In addition to the vast amounts of newly discovered evidence that has been in the hands of law enforcement and the prosecutor's office for over 10 months since the defense entered their appearances, the defense has also received certain new evidence that was only recently produced, including a new audio file in which blank was interviewed by state police in August of 2023. A new audio file in which blank was interviewed in August of 2023. A new audio file of blank who was interviewed in August of 2023. A new audio file in which blank was interviewed on September 9th, 2023. This is believed to be the mystery Purdue professor described in the Faxx memorandum. His name is Jeffrey Turco. The state of Indiana was apparently aware of his existence since September 9th, 2023, but did not inform the defense of his existence until the defense found his name in a September 27th, 2023 evidence dump. Number 14, between the vast amounts of old discovery that has been in the hands of law enforcement for over 10 months, including exculpatory evidence that supports the defense theory of Richard's innocence, as well as the Todd Click letter that had been in the hands of the prosecutor since May 1st, 2023, a letter that led to exculpatory evidence that supports the defense theory that Richard is innocent. The defense is concerned that there will be a continual drip, drip, drip of evidence, much which could be exculpatory in nature, unless a discovery deadline is set by the court. Number 15, of course, the defense is not seeking a discovery deadline on any exculpatory evidence, as the state of Indiana has a continuing obligation to provide exculpatory evidence to the defense when the state of Indiana, is aware that it possesses exculpatory evidence. Number 16, the defense is requesting that the prosecution produce all evidence in its possession immediately, and also that the court set a November 1st, 2023 deadline to do so. Number 17, additionally, based upon the state's recent discovery of new evidence, such as the August 2023 blank and blank interviews, it is the defense's view that following the defense's team's first round of depositions, that the state has reopened its investigation. While defendant Allen takes no exception with the state reopening its investigation, directing its focus on other suspects in this case, defendant Allen desires that there be some end to the offering up of new information, as well as parameters as to when and how the state of Indiana should turn over new evidence stemming from the reopened investigation into the odinism aspects of the case or any other aspect of the case that is still being investigated. Number 18, pursuant to LR 08-CR00-18, defendant Allen acknowledges his responsibility to seek out full discovery under terms of the standing order on discovery. In this respect, and to conform with the local rule, defendant Allen directed to Carroll County Prosecutor Nicholas McClelland additional requests for discovery the following dates: a letter dated August 22nd and a letter dated August 28th, 2023. Number 19, defendant Allen believes he has received a portion of the discovery requested in the above referenced letters. Number 20, however, to the best of the defendant Allen's knowledge, he still has not received the following discovery that has been requested upon the state and are particularly important, as they may very well contain exculpatory evidence that will support the defense theories of who actually murdered the girls. Blank audio videotaped interview from February 17th, 2017, conducted by S.A. Adam Pohl and Hammond police officer Christopher Guti. The body of the report concerning the interview states the following: the below is an where did the rest of this go? Hold on a second, guys. Like, where did the rest of that go? There it is. I'm like, what? In the interview summary, it is not intended to be a verbatim account and does not memorialize all statements made during this interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. The defense requests the recording so that it can utilize all actual words spoken by blank at his interview. Additionally, in his August 2023 interview, blank discusses a second interview with law enforcement that took place years ago. The defense requests all reports and recordings of that interview. Blank was interviewed on February 19th of 2017 by the same law enforcement officers that interviewed blank 2 days earlier. The defense has not been provided any electronic recording of that interview. A report believed to be authored by Purdue professor Jeffrey Turco, defense has not found this report in any of the newest discovery. Police reports related to blank reporting her brother's confession in person in Carroll County sometime in February or March of 2017. Number 21, the state of Indiana has indicated that it has not been able to locate items A, B, C, and E in paragraph 20. The state has previously indicated it could not locate the Purdue professor or any reports he had authored, although that may have recently changed. At the time of this filing, the trial in this cause is just over 3 months away. Defendant Allen understands that there likely will exist additional discovery in the form of audio and video surrounding the defendant's detention circumstances, which will continue to be requested and presumably disclosed in the event that this honorable court takes no action of defendant Allen's recent motion for immediate transfer. However, defendant Allen requests that the state of Indiana be required to offer up totality of all other discovery no later than 30 days from the date of this request. Without a firm discovery deadline, it is impossible to conduct depositions and to engage in pretrial hearings. And hearings on motions in limine, without the totality of all discovery in this cause being provided to the defense. Trial Rule 26B provides that the defense may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable matter. This investigation has been ongoing for more than 6 years. Again, with the understanding that there may be some additional discovery related to defendant Allen's detention circumstances, there is no reason why the defense should be receiving discovery that has been in the hands of law enforcement and which continues to be quite voluminous at this late stage in the proceedings. The need for a discovery deadline exists. Wherefore, defense counsel respectfully requests that the court set a discovery deadline no later than November 1st, 2023, as defense counsel believes that said deadline is necessary to promote defendant Allen's constitutional due process rights to be confronted and presented with all evidence concerning the pending allegations, and to promote the need for judicial economy as the trial in this case draws near, and to permit the defendant Allen and his attorneys to be fully informed as they engage in further depositions and pretrial matters in this cause. Respectfully submitted, Bradley A. Rosie, Andrew J. Baldwin, attorneys for the defendant. So, he is claiming that there's a few things that I took from all of that. He's claiming that Tony Liggett and Jerry Holman absolutely withheld exculpatory evidence from the defense for months. They did not want them to have it, is what they're saying. And hey, Ray Jones, how are you? Good to see you. Hey, Grizz, how are you? So good to see you, my dear. And they're basically claiming that. Now, when they talk about the fact that the state has reopened the investigation based on the defense bringing up the Odinism angle, they didn't reopen anything. If you remember when they arrested Richard Allen last fall, Nick McClellan made it absolutely clear that they were continuing to investigate this case and that any and all other players or actors that may or may not be involved in this case would be brought to justice, that they would be continuing their investigation. So this investigation was never closed. It was never something that they had to reopen. Again, that's the defense trying to make things seem as to what they're not. And I'm sure that once this gets into court and this motion, and they're called into court to talk about these motions with the judge, there's going to be a lot of things that are said by the prosecution regarding all of the stuff that has been put into these motions about the so-called exculpatory evidence that they supposedly were not given. It sounds to me like they were given it, but maybe not in the time frame that they wanted it. Again, this is 6 years of information and info. And before they just turn stuff over to the defense, they have to go through it themselves, you guys. This is not something where they just say, oh, here's some notebooks and, have them read them, see what you can find. That's not what they do. That's why, if you recall, a year ago, was it this past? Yeah, a year ago, this past February, when sorry, guys. Sorry. Yeah, in 2022, February of 2022, Doug Carter sat down and did an interview. And in that interview, he said, we are going to need about 60 to 70 additional law enforcement officers once an arrest is made. And what he was talking about was people to go through all of the evidence, people to go through all of it so that they could get it all into a file of some kind that they could turn over to the defense. They needed to go through all of their stuff, make sure they didn't miss anything. It is imperative in these types of cases that the prosecution not miss anything. It is up to them to turn over all evidence to the defense. The defense and the Constitution affords that to the defendant so that they can put together a compatible defense of themselves by knowing what all the evidence against them is. So there's nothing wrong with Richard Allen's asking for that or demanding it or whatever. But you have to remember that this all takes time. And we're talking about a case that is huge, lots and lots and lots of evidence, because we're not talking just about physical evidence here. We're talking about depositions. We're talking about interviews. We're talking about reports. We're talking about anything that was investigated by police. We're talking about experts' reports. There's just so much. And so it's really super important that the prosecution makes sure that they have it all. So I think they're just pulling at straws here because they want what they want and they feel like things are not being given to them in a timely fashion. Now, this whole thing about the fact that they were suppressing this information or deliberately not turning it over to the defense, I don't buy it. I don't buy it for 1 second. The reason I don't buy it is because I cannot absolutely see them wanting to, after all the work that they've done to get this far, I can't see them doing something like that to get the case thrown out. And that's my opinion. Just my opinion. I'm not a legal expert. I'm not, I'm just me. But that's kind of how I feel about it. I just don't see it. I unless it's proven, I'm not going to believe it. They can say whatever they want to. Again, we have to remember that's what the defense's job is. The job of the defense is to try everything under the sun to get their client off. That's what they're doing. So anything that the defense does at this point in time from now until January will not surprise me at all, because that's what you want. If you're a person who has been charged with a crime, and especially a crime so serious, you want a defense that are bulldogs that are going to go after every single possible thing, whether it makes sense or doesn't make sense. You want them to give you every opportunity, and that's what they're doing here. And hey Melissa, how are you? Good to see you. And I still think for them to sit and say that, that law enforcement doesn't care about this Odinism angle. You know what, guys? Come on. What in the world do you think they were all thinking that day when they walked, all of those law enforcement officers that are from the, command that they talk about in their filings, stood around those girls laying there in the woods looking at that crime scene? They doggone well cared. They wanted to get to the bottom of who did this brutality to these two young girls that didn't deserve it. If you don't believe that, then you think that those men standing around there looking at those girls in the scenario that they were found, they're monsters. Because anybody with any humanity left in their bones would want to get to the bottom of who did this. So I'm like, there are, it's real easy to throw out there this whole conspiracy theory stuff, you guys. But the number of people that would need to be involved in a conspiracy is ridiculous. And there's just no way. Now, is it something else? I don't know. I want whoever did this to be prosecuted at the fullest extent of the law and the book thrown at them. That's what I want. Is it Richard Allen? I lean to that by what I've seen so far. But we don't have all the evidence. We have not seen all the evidence that the state has. We haven't, I guarantee you, we haven't even seen a third of the state's case. And if you think for 1 second that the defense is going to come out in a motion and give you the entire state's case, they don't know what the entire state's case is. They find that out in court when the evidence is presented. I'm tired of this mindset in our country where everyone thinks that everyone who puts on a uniform in blue is corrupt, evil, and up to no good. I'm sick of it, you guys. I really am sick of it. I mean, come on, let's use our brains here. What in the hell would be the reason that they would want to do something like that. We're talking about a brutal murder of 2 little girls. It just doesn't make any sense. It just doesn't. And I said it before, and I told you this before. One of my moderators from my subreddit, Delphi's Daughters, deep dove this group. They deep dove this group extensively. I looked at what she found. I saw the photos that the defense has talked about on the social media accounts of these individuals. I know what they're talking about. And this is not new information to social media and to any of us who have followed this case since day one. We all were aware of it. And what has come out, and I haven't seen an affidavit from the Purdue University professor. And until I do, I'm not going to just go running off with exactly what the defense is claiming, because it is completely different than what the state said. And what the state said in their depositions to the defense, supposedly a month ago. And because we have that discrepancy, until the defense can prove it in the court of law, in front of the judge, and not just on paper in some motion, I'm not going to buy into it. Mike and Becky Patty have lived in Delphi and Carroll County for a very, very long time, their whole lives. Mike Patty knows these officers. I don't for one moment think that any of these officers would do anything like that to him. Yes, Melissa, I talked about that at the very beginning of my live stream. We went over her case. It's awesome news. Awesome, awesome news. And that's where I fall with this whole thing. It is so easy to play armchair detective or Monday morning quarterback and call all the shots and say all the things that you wouldn't do and all the things you would do and all this other stuff. And I'm like, you know what? All the critics of this case that are like that, I think they need to go apply to be a police officer, because there is absolutely a huge shortage of police officers in this country, not just in Indiana, not just in Delphi and Carroll County, but in every county in this country. And if there are people out there that think they can do a better job than what was done in this case, then they need to put their money where their mouth is. They need to go apply and try and do this job in this day and age. It is dangerous, beyond dangerous, and it's hard. And these murder cases are not easily solved as it sometimes appears it should be. Just like I said, the fact that they found Charlotte so quickly is just remarkable. What amazing police work. How they all came together and worked together as a team. Because that's what has to happen. And you can't have all these egos running around and all this stuff. You just can't and expect to get anywhere. And I can tell you that in this case, early on, there were some egos and there was some back and forth, because I know from following the case so closely that there were investigators that believed this, and there were investigators that believed this, and there were FBI agents that believed this. And they weren't all on the same page. And if you're trying to have a coordinated investigation with great communication, and you've got multiple jurisdictions and agencies trying to work together and coordinate, you have to get on the same page. You just have to. Now, the fact that they have this so-called three, I think it is, law enforcement officers that believe that these other individuals perpetrated the crime, fine, put them in Delphi. Put the evidence out there. Put them with the girls. Don't just sit there and say it's a possibility. Prove it. They are ruining these people's lives by naming them in documents. They've never been charged by police. They've never been, they've been interviewed. Of course they were interviewed. You know why? Because all the people that were looking into the whole Odinism and Odin group scenario were turning them in. They were calling the tip line. They were turning this stuff in and giving tips. There were tons of tips on these people. Tons. I know that. Factually, I know that. I'm not speaking off cuff here. And is it something that's kind of like, when you look at that, is it possible? Sure, it's possible. Until you start looking at the evidence. And when you have someone who's the number one person that they're naming in this group, who has an alibi, he was at work. Where do you go from there? How they don't talk about that. That's in their discovery. But they don't mention that. Do you notice? They don't mention the fact that law enforcement investigated all of that, and that they did go and they did find out that what number one suspect they're talking about was at work. That's not in their little memorandum to the judge. They left that out. It's okay for them to leave out stuff, but not okay for the defense or for the prosecution. And that's the other thing. There is a disparity in how the process works, because the burden of proof, according to our Constitution, is completely and solely on the prosecution in every case. They have to, by the preponderance of evidence, they have to prove their case beyond a reasonable doubt. What happens in court is what becomes a reasonable doubt. And that is, to me, is a big issue, simply because it can vary from person to person. What is reasonable to me may not be reasonable to Boston Christian, or it may not be reasonable to Melissa or anybody else watching. We all may have a different idea of what reasonable doubt is. And yes, see-through, I get you. They're talking about how the timeline doesn't work, but they don't talk about the fact that there's eyewitnesses that see him after 1:30. After 1:30 on the trails and at the bridge. I mean, it's just crazy. But like I told you guys when we met last time and we talked about this case, um, there's going to be a lot of things that are said pre-trial, and we just have to try and remain calm and not let everything that we hear or read cause us to lose our minds, because we know that the defense is going to try and throw everything they've got at the wall to see if it sticks. It's what they're supposed to do. They're supposed to try and defend, their clients. Good question, sees through. Those are questions that will come up in court. Those are questions that the prosecution will definitely be bringing up in court when they go over the timeline. I am anxious, you guys, anxious to hear the opening statement from Nick McClelland. I cannot wait to hear what Nick's opening statement in this case is going to be. And the thing that bugs me about this motion and this filing, where they keep saying that these are the guys who perpetrated it, nowhere in their little 134-page write-up do they say what's their evidence that they were there. Just because you have some sticks that you might think look like runes doesn't make them guilty. The perpetrator of the crime staged the scene. The FBI told them that the scene was staged to appear as something it was not. Runes, guys, does that ring a bell? Staging? Come on. I don't know. I just, like I said, it's there's just so many things that give you cause to pause and think about a lot of different things. Like I said, will I be surprised if there are other people involved in this? No. Will I be surprised to find out that Richard Allen is not Bridge Guy? I would be floored. Not surprised, floored. And again, you guys know what it's like. You know what pareidolia is? You guys have heard of pareidolia. It's what we see when we look in the clouds. You know how when you were a little kid and you were driving on a road trip with your parents, and maybe you guys are way younger than me, but back in the day when we would do road trips in our cars, one of the games we would play is, what do you see in the clouds? What do you make out? What kind of things can you make out? We all see things differently. We all see things differently. So one person who looks at the sticks that were placed over the girls may see one thing, and someone else may see something completely different. Whatever it was enough to shock investigators, because Robert Ives said it was like no other crime scene. It was unusual, is what he said. Unusual. What made it unusual? I think it would be really unusual to find one victim completely dressed and another victim not, and another victim completely undressed. I would think that would be highly weird for me. What would, you would think that would be odd. So, just remember as we're going along with this, as I've said before, the family is out there. They're listening to this. They're hearing this. They're seeing this. They're having to read these court papers and documents just like we are. And it's painful, guys. This is not easy for them. And if you think for 1 second that this gets us all riled up and our blood pumping and everything, stop and think about what it does to Anna and to Becky and Mike and to Carrie and Derek and Kelsey. Stop and think about that. I find it extremely unlikely that a cult or a Odinistic cult or whatever you want to call them decides that they're going to do a ritualistic killing on a Monday afternoon in the middle of broad daylight of 2 teenage girls. I can't wrap my head around that, you guys. I just can't. Ritualistic killings are very rare. Very rare. And you know what, John? Even if they didn't find any material, you don't have to have material to know. I knew about Odinism. I don't have any Odinism material. It's all over the internet. All you have to do is look it up. We know that there is a faction in that area of Indiana that has it. We know they're groups. Maybe he was a huge Odin and Thor fan. Who knows? I go back. One of the things lately that I've been really thinking about is when Doug Carter told us, that there's a lot of tentacles. And, Frank Meister said here just a little bit ago about the defense is trying to pull a, what did he call it? Oh, let me find it. A rope-a-dope. And, and all those cell phones that they found, they didn't talk about them being burner phones or anything like that, you guys. It could actually just be the fact that he kept his old cell phones. Lots of people do that, They have a drawer and they just throw them in there. Hi, Lisa. How are you? It's good to see you. But we don't know everything yet. And it's hard to speculate when you don't know everything. You can read into so much. You can read into stuff that's not there. And we have to be careful of doing that. Confirmation bias, you guys, is a real thing. And until you're able to actually, figure out what it is and be aware of it for yourself, it is a really hard lesson. So, what is confirmation bias? Confirmation bias is the tendency for us to interpret new evidence as confirmation of our existing belief or theory. Now, you've got to remember the defense, in my opinion, has confirmation bias. Why? Because the defense is trying to defend their client. Their whole purpose in this case is to get Richard Allen off. So every new piece of evidence or anything that they consider, they're going to latch onto as exculpatory that may point to someone else. Our tendency to process information by looking for or interpreting information that is consistent with our existing belief systems is biased. And this is how most people approach decision making. It's largely unintentional, but it results in us ignoring information that is inconsistent with our beliefs. And these beliefs can, include our expectations in any given situation, and how those predictions are going to affect a certain outcome. People are especially likely to process information supporting their own beliefs when the issue at hand is highly important or self-relevant. So when I was taking psychology and we were in college and we were talking about confirmation bias, we talked about how human beings sometimes process the information illogically and in a biased manner. And for example, the manner in which we as human beings know and understand the world is often affected by factors that are simply unknown to us. So philosophers over time have noted that people have difficulty processing information in rational and unbiased manners once they have developed an opinion about an issue. We are better able to rationally process information, giving equal weight to multiple viewpoints if there are emotionally distant from the issue. When we become emotionally invested, it becomes harder and harder. And another explanation as to why people are susceptible to confirmation bias is that it is an efficient way to process information. We are constantly being bombarded with information. And we can't possibly take the time out of every day to process each piece of information that's coming at us to form an unbiased connection or conclusion. So our decision making and information processing is often very biased because we're limited to interpreting information from our own viewpoints. We have to process information quickly to protect ourselves from harm. And it's adaptive for us to rely on our instincts and our automatic behaviors that keep us out of harm's way. When we are making decisions and confirmation bias, examples of it, I mean, in the context of decision making, once we make a decision, we're going to look for information that supports that decision that we made. And if any information comes in that conflicts with that decision that we've made, may cause discomfort and cause us to ignore it or give it little consideration. And we do give special treatment to information that supports our personal beliefs. When they have done studies examining my side bias, which is where people are asked to generate and remember reasons supporting a controversial issue, they're able to remember more reasons supporting their side of the equation rather than the opposing side. Only when people are asked to give arguments against their own beliefs are we able to really do that. We're just not motivated to do that. When human beings are looking or seeking information to support our hypothesis or expectations, we tend to look for positive evidence that confirms that a hypothesis is true rather than information that would prove it false. And a lot of that happens when, you guys have probably all been in this situation before where you are told what to expect from someone that you've never met before, but you're about to meet. They might tell you this person's very warm and friendly and outgoing. You're going to look for information immediately to support that. So another example would be if Maria expects her roommate to be friendly and outgoing, she may ask her if she likes to go to parties rather than asking if she often goes and studies in the library. The implications about confirmation bias in the real world, in law, in medicine, in our interpersonal relationships, the implications are so important. Research has shown that medical doctors have confirmation bias just like everyone else. Doctors have a preliminary hunch regarding the diagnosis of a medical condition early in the treatment process of a patient. And that hunch can actually interfere with that doctor's ability to assess information that may indicate an alternative diagnosis is more likely. And that's what happens when people are misdiagnosed. Another confirmation bias is related to the outcome of a diagnosis. Patients are more likely to agree with their diagnosis if it supports their preferred outcome than a diagnosis that goes against their preferred outcome. And so the implication is that confirmation bias has implications for individuals' health and well-being. In the context of law, such as in this case, Judges and jurors sometimes form an opinion about a defendant's guilt or innocence before all the evidence is known. Sound familiar? Once the judge or the juror forms that opinion, confirmation bias is going to interfere with their ability to process any new information that emerges during a trial, which may lead to unjust verdicts. And so that is why it's so important for us to be aware of confirmation bias, especially our own, and just really, yeah. Hey, Steve, how are you, my dear? It's so good to see you. I think that what happened was, in my opinion, I believe that they did vet these individuals. I do believe they investigated them. I believe that they looked at this angle and they did move on from it. I don't believe that they thought it had any bearing on this case. It's like I said before, you have to be able to place that person on the bridge in the woods with the girls. It's just not about what you think or feel. It's about what you can prove. And we're just going to have to wait because, all the evidence isn't out there. We are going to find out so much more when the trial commences. And yeah, we just have to try and keep level heads while we're going through this process. But that's all I really had for you guys tonight. And I hope that you guys all have a wonderful rest of your week. It's turning cold here this week, this weekend. Right now, it's been unseasonably warm by almost 15 degrees. And we're getting some cold fronts moving through in the next couple of days. And the football game I have to go to on Friday night, I think it's supposed to be like a high of 52. So I'm going to be chilly at that game because I'm already cold all the time because of me dropping the weight the way I'm dropping it. So yeah, I'm freezing all the time, you guys. It's just crazy. But I feel great. And I just can't say enough about how I got my life back. And I just feel amazing. So nobody said that he racked it over two deceased girls. I don't believe he did that over two deceased girls. I think that if he racked that gun to scare them, it would have been while they were both still alive. Oh, yeah, no kidding, Deb. I'm going to be definitely bundling up, and I'm going to have my hand warmers. So, but yeah, it's that time of year. I love October. It's my favorite time of year. We'd celebrated my daughter's birthday on Sunday, and then my grandson, who's the kicker on the football team, his birthday's next Tuesday. My baby grandson, who turns 6 on the 13th, his birthday's 3 days later. His daddy's birthday is on the 16th. And then my best friend's birthday is on the 23rd. And then, of course, mine's on Halloween. So it is a busy, busy month for me in October. But the 16th is also the anniversary of my son passing away. So it's always a really bittersweet time for me this month. But I've tried in recent years, especially in the last 10 to 15, to try to, keep my joy about October going, because I love it. It's always been my favorite time of year. And yeah, so, but I've been working out and feeling amazing. Like I said, feeling amazing. I just can't say enough. Oh, that's cool, Deb. That's so cool. Yeah, May and October is our months. I mean, my oldest grandson, he is a straggler. His birthday's in January, so he's like the odd man out of the whole family. Everybody else was born in May or October. So, but yeah. So it's I got a busy week next week for sure. And I don't know. I can't believe, honestly, I just can't believe we're this close to Halloween, and I can't believe that we're this close to Thanksgiving and Christmas. I'm like, where on earth did this year go? But I'm still diamond painting away, guys. And I have, I'm going to have to put together a little slideshow and show you guys some of my diamond paintings that I've done. But, so I'm still doing that. It's really, really, really helped with my anxiety. And I think that that's another reason why I feel so wonderful. So, but, and my jumping spiders, I think I told you guys about them a while back, that I have jumping spiders as pets. They are all doing fabulously well. My first female Wednesday, she has actually had 2 clutches of babies, and 2 egg sacs of babies. And man, that's been an interesting experience, guys. But I'm loving them, and they all sit here on my desk. I have them in their little enclosures. I'll show one of them. Hold on. This is one of Wednesday's babies. This is Chai. I don't know if you can see that, but it's a coffin enclosure shaped like a coffin. And Chai's up here right now, up here on the top. But yeah, I have them all decorated. Jumping spiders they live up above. They don't like live on the ground. So they only come down and around in here when they're searching for their fruit flies or their crickets or whatever. So I absolutely love them. I love watching them. My grandson, he has been, it has been the most amazing experience with him. And I love spiders. I found out a long time ago that spiders are not bad, and that they've gotten a bad name, and people are afraid of them. But if you can get over your fear of them, they're amazing, amazing creatures. So, oh no, Tech Death, where's the active shooter at? I'll show you Wednesday's enclosure. She has a bigger one, but this is Wednesday. So she has the the large coffin crib. And as you can see, I know it's really hard because there's such a glare from the camera on, or from the lights, I think behind here maybe. But I don't know if you can see it or not. But anyway, she's right up here. She just came out because she hears me talking, and she has a I don't know if you can see it right here is her nest. Her new nest is right here. Her little this will be her third egg sac that she's done for me. But yeah. And when the babies hatch, I keep them until they have their third instar, which is where they change their clothes, guys, because spiders shed their skeleton, and that's how they grow. And so after they do that 3 times, I put them out. I let them go. So, but some of them, I have kept a few of them that just kind of caught my attention, or however you want to put it, my heart. I love watching them. They're just amazing. They do not bite, Deb. They can bite, obviously, but jumping spiders do not bite people. They are so truly amazing. They will crawl on you. They have amazing eyes. They're super cute, actually. This particular spider, if you guys hold on before I get off, I'll show you what I'm talking about. Hold on. Let me get this image and we'll show you guys what it looks like, because they are adorable. And so that's what they look like. Now the ones that I have is Phidippus audex is the species that I have, and that is one. Let me see if I can click on them. And that's this one here, which is the bold jumping spider. And this is the picture of what mine look like. Mine look like this. And they are, like I said, I love them. They are just beautiful. And it's fun. It's a big hobby. I didn't realize until I got into it how big of a hobby it is, you guys. Seriously. And it's funny because my family, they just kind of look at me like, oh my God, she's lost her mind. But no, I think they're really amazing. Give them a chance, you guys. Read up on spiders and stuff. And yeah, there are sure there's spiders out there that are deadly to humans. You have to be careful of those. But most spiders are not going to bother you. They don't want anything to do with you. They want to be away from you. And they eat the really bad insects. And yeah. Oh, Tech Death, that's awesome. I would love it. That's so awesome. Yeah, they're just cool little creatures. I just think they're amazing. So, but anyway, guys, everybody be safe. Take care, and please make sure that you treat everyone with kindness. Being a kind person isn't hard, and it doesn't really take any effort. So that's just my mantra. And I know you guys know that, but that's all I'm going to say to that. But I will see you guys soon. Take care of yourselves, and Purdue RN, if you're still here, and Deb and Frank Meister, I cannot wait to meet you guys on the 21st. And, I feel terrible, Tech Death. I will for sure That just breaks my heart. I hate it. I just absolutely hate every time we have these mass shootings. It's so, so sad. But anyway, love you guys. See you all soon. Good night, everybody.